Piggybacking on some of the stuff I've already said, if you can show that the transfer was in the ordinary course of your daily life, that this was nothing that was unusual or out of the ordinary, that's a reasonable defense. That you got a reasonably equivalent value in exchange for the transfer, that's another. And another that I haven't mentioned, but that bears bringing up now, let's say you transfer money to a charity. I have clients who, for example, may be Mormons, and part of their church's teaching is they have to give 10% of all of their income to the church. Well, what are they getting in exchange for that? You might say they're getting some sort of psychic or emotional benefit from it, but they're not getting a reasonably equivalent value in exchange for the transfer as far as money for goods. The bankruptcy code has a carve out for that. Now, you are not going to be able to get away with giving 50% of your money to your church or your organization. But if it's a legitimate charitable organization as defined in the Internal Revenue Code, and if this is something you're regularly doing, then that will also not constitute a fraudulent transfer. So that would be a defense that you could use as well. Although I will say it would be a rare circumstance in which a trustee mounted a fraudulent transfer avoidance action based on a transfer to a recognized charity. But certainly the key definitions, this is in the ordinary course of my daily life. There was a reasonably equivalent value in exchange for the transfer. You might wonder about that second definition, by the way, the reasonably equivalent value in exchange for the transfer. You've got this asset, you transfer it to somebody, you get a reasonably equivalent value in exchange for it. This thing still has the same value as the prior one. So whatever is going into the bankruptcy estate, it hasn't changed its value. There can be some tricky things here when it comes to taking an asset that is non-exempt, transferring it and getting an exempt asset in exchange for the transfer. That gets into a very delicate area of pre-bankruptcy planning. And as a case law note, I will mention a case that came out of the Ninth Circuit some years ago. An interesting case. The attorney representing the debtor is a friend of mine. So I do have a little bit of knowledge about this particular case. Anyway, so what happened was, in this particular case, the debtor was an attorney, and not my friend, but my friend's client was an attorney. And he was facing a lawsuit and what looked to be something on the order of a judgment of $500,000. And he decided it was time to file a bankruptcy because this debt would have been dischargeable. Simultaneously, he was in the process of a divorce. And he and his estranged wife had assets totaling something on the order of $2 million. $1 million of those assets were non-exempt assets, and $1 million were exempt assets, retirement funds, that sort of thing. And so he said to his soon-to-be ex-wife, look, we're each going to get $1 million worth of assets. How about if I take the exempt assets, you take the non-exempt assets? It's a fair swap. We each get 50-50. But then when I file the bankruptcy, my assets will be exempt, so I'll get to keep them. So this gentleman filed his Chapter 7 case based on that theory. Well, that did not work out. In fact, this went all the way up to the Ninth Circuit Court of Appeals. And the Ninth Circuit came to the conclusion that the bankruptcy court had come to, that this was a fraudulent transfer. That they didn't say this in the decision, but I suspect that if he had gotten 50% of the non-exempt assets, 50% of the exempt assets, it would have passed muster, because at least there would be non-exempt assets to pay creditors. But instead, he took non-exempt assets that could have been used to pay creditors and transferred all of them to his ex-wife, and in exchange, he got all the exempt assets. So that meant that not only did the Chapter 7 trustee in that case get the power to avoid the transfer and seize the non-exempt assets, but this gentleman was denied a discharge under Chapter 7 because the transfer had been done during the 1 year pre-petition period. So one does have to be very careful with even doing transfers to change the nature of an asset from exempt status or from non-exempt status to exempt status. This is a very sophisticated area of law, and if you are not really a skilled attorney in this particular area and you think you're going to do it, it will bite you. This is not for the uninitiated, and even the initiated can find themselves in real trouble. As a matter of fact, the attorney who is my friend is a very good bankruptcy attorney. He's been doing it for many years, and even he did get bitten on this one. So be very, very careful.